What's going on, everybody? This is Lady Luck. All right. So I have been getting some information together to do some commentary and to just kind of talk about the election board hearings and my thoughts on it. And just some basic information that I was able to look up. I'm not going to make this a long video because the second board hearing that was conducted was over 2.5 hours or so. And then the last one that was on yesterday, that occurred on yesterday, was over 5 hours long. This is all about Dumb and Dumber's objection to Napoleon Harris's residence. That's what this whole thing is about. And I wish to God you all would vote in an entire election board in Thornton Township. You need a whole new damn board. Preferably those who are attorneys and are well versed in election laws. Because I'm telling you all right now, one of these older white women up there sitting on the board, she just oozes dents. And it's irritating because you hear Napoleon Harris's attorney give actual case law, shows precedents, cites state statutes, and references Thornton Township, the election board rules over and over again. And it gets ignored by someone who seems to be more insulted at someone telling her about a law than her thinking objectively about the situation and actually reading the law for her damn self. And I just, I'm going to say this. I'm all for diversity and everything, but I'm also for representation. Everybody up there is white. I don't see now one African-American black person up there at all on the election board. And clearly, they want to drown this out and just prolong it well beyond how it needs to be. This is an objection on his residence. Dear God. It's almost like, okay, what are you looking for? So we're going to go over just some parts of the second hearing and then some parts of the third hearing. I'm not going to play the whole thing. I'm just going to kind of give a synopsis of it overall and then go over some information that I was able to find online that I think you guys will find helpful to kind of help you understand why I yelled at my phone more times than I can recount at this point, because these people are infuriating. Dumb and Dumber still know nothing. They're not attorneys. They filed this stuff wrong. They filed the objection, oh Lord, on the 23rd at 3:45 p.m. of December. 23rd of December at 3:45 p.m. Who trying to be at the office on December the 23rd at 3:45 p.m.? They wanted the clerk to sit here and cater to their dumbass tantrum that they're throwing on behalf of a super stupid who's not even on the ballot now, can't get on the ballot by the court by court ruling. And the only way she could even remotely land on it is if she's a write-in candidate, which she probably more than likely is not going to be eligible for at that time, because she's definitely not right now. She's not even insurable, so she can't get bonded. Amongst the fact that she just lost the caucus because she failed to read caucus rules. So no one wants to read anything, but yet they want to throw a tantrum when people point out why reading is fundamental. This is ridiculous. So we're going to check out this vile waste of tax dollars and from the second hearing. And man, I want you all to hear this opening from Napoleon Harris's attorney. I just think it's awesome and epic. And say what you want. Him and his co-counsel, and I think he has his paralegal there with him. They're about the smartest people in the room. And, yeah, that speaks volumes.
Mr. Residency, is there a motion?
I will start off. The first point is that the objectors filed a verified petition. And their verification does not say anywhere upon information belief. It says we have personal knowledge of all these facts and these allegations. In their response, the true nature of this objection comes out. And it's a quote. This is the worst kept secret in Thornton Township. If we wouldn't go by gossip and innuendo, we will be here literally, for days and weeks.
Mm-hmm.
If they had personal knowledge and facts, those should have been pled. This is no different than when someone files a mortgage foreclosure or some other verified pleading seeking this type of relief to remove a candidate. But they chose not to. And the reason why they chose not to is because they don't have a case.
Right.
And this even becomes clearer. Point 2. They changed their objection. The objection now is my client never lived at the Harvey residence. That's not pled anywhere. How is my client supposed to mount a defense if the objectors are going to make these shifting arguments? I cite the Maskin case, and they want to talk, it's all about proof. They're wrong. Maskin talks about what must be proved, but what must be pled. They have never pled in this case that this is an abandonment case. So what documents do I have to gather for this case? They don't. They don't point out that, are they saying that this 30-day rule about residency under the township, you have to live in the precinct and be registered to live there for 30 days before, are they going to be counting the time that my client who's in Springfield is done?
It's done.
They have not provided any information. I cited the Daniel case, and the reason why I cited Daniel versus Daly, and they want to talk about, well, that was kind of a shotgun objection because it dealt with signatures. This is no different than a shotgun objection. You're not a resident. We're gonna shift the burden to you, Mr. Senator Harris, to show that you're actually a resident. The burden's on you. We've provided you with enough information. One of the best known facts is Senator Harris owns a Beggar's Pizza and several other Beggar's Pizza. One of them is in Harvey. His Harvey residence is right by his restaurant.
Yeah.
There's an article, we provided an article where he's actually worked in the restaurant. So, okay.
So far, basically, the objection was filed on the residence where Dumb and Dumber, Michael Smith, who still knows nothing, and Keith McChickennugget both claimed that, or alleging that Napoleon Harris does not live in Thornton Township. All right. So therefore, he should not be on the ballot because they're not attorneys and they're not that smart. They didn't file it correctly to begin with. It was not based upon any finding of fact or law. 1, 2, they didn't even preserve the exhibit itself, the objection itself properly according to rules, which is also based on state law. And 3, what he's saying is this: the case law that I've cited is not necessarily just about, the proof in and of itself about residency. It's about how they're pleading. What are they alleging? They're asking for relief in the form of Napoleon Harris being taken off of a ballot. That's a mighty tall glass to fill. So if you're going to ask for some type of relief to that statute, that's a hot big glass to fill here, then you need to have a plea or the objection in and of itself that is solid enough based upon the finding of fact and law to show that he does not live in Thornton Township. You need to have irrefutable proof and evidence to prove that. Otherwise, what the attorney just said, what the counselor for Napoleon just said, they're making an allegation. They come into the personal knowledge, but they didn't provide any facts or evidence to support it. So basically, it's at best presumptive, at worst hearsay. And they are asking an election board to say, because of our personal knowledge, we're objecting and we want you all to take him off the ballot because we believe he doesn't live here. You have to prove that. And that's the most insulting part about this. And I've said this in the first video that I did where I covered the election hearing where Michael Smith just got his ass chewed up. You can't just go in making an allegation and you have no evidence. But to sit here and go back and forth when you're not even giving a viable, legal, lawful objection that was not properly written or filed, well, you're not making a plea for anything. You're not pleading that he's not there. You're not saying here's the evidence to show he doesn't live there. You're saying I came into personal knowledge of, and you're being presumptive. And probably just through word of mouth, which would make that hearsay. And you want this board to take him off the ballot, and then you want us to help you meet your burden. What an insult. What a damn insult. We're not gonna help you meet your dumb burden. For a dumb case that you did not have to file, for a dumb objection you don't understand how to file or even fill out correctly. They couldn't even figure out if they had 2 or 3 pages. This is how stupid it was. And they wanted a clerk to come in on 2 days before Christmas at 3:45 p.m. Which she did. She didn't have to do it. I would have cut my phone off. Calling me at 3:45 on the 23rd of December. You typically trying to season up your turkey. You get ready to make a Christmas meal. You sitting here calling me talking about, I need you to come down here and file and stamp this stupid ass objection. That was missing a whole page. They alleged, it was 3 pages in 2. Then he's talking about, aside from them wanting the Napoleon attorneys, the objectors, now Dumb and Dumber want Napoleon's attorneys to help them meet their burden in a simple matter like this. Why? If it's based on evidence and proof that can be documented regarding the residence of Napoleon Harris being verified that would deem him eligible to run as supervisor of Thornton Township, why do you need anyone to help you meet that burden? Just supply your evidence to prove that he does not live in Thornton Township. That's it. Cut and dry. You won't need witnesses for that. It's not even supposed to be this convoluted and complicated. But because 2 thunkheads that don't have a brain are following the marching orders of super stupid, who's also as dumb as it comes, then they're just going in and taking a shot in the dark as opposed to sparing everybody what's a vile waste of tax dollars and time. A vile, vicious waste of tax dollars. And these goons sit here talking about, they're spending money and they're doing this, that, and the third. These are the same idiots that won't put super suit in her place. They kiss her ass all day. They will not tell her what she needs to know because they're so scared of being fired. But yet they want to sit here and talk about how they are for the people and they are what the people want and all this other stuff. At the end of the day, I wish you all would just start asking them, look, you claim you for the people. Why don't you help me pay my rent for 6 months? Let's see how fast they'll help the people out and pay some bills out of their own pocket. Good luck to that. Because they don't do shit else. Michael Smith does nothing. Keith the Hamburglar maintains the food pantry because that's like right up his alley. And then do what? Nothing else? Run his mouth? Be real flippant at the mouth. Smart mouth. For what? It's not our fault that you're oozing mayonnaise. And then on top of everything else, they're sitting here literally wasting tax dollars by having these dumbass hearings on an objection on residents that they can't prove. It is their burden as the objectors. If this were a matter in court, it would be considered the petitioners. It is their burden to meet, to show that he does not live, because they're the ones bringing forth the allegation. They're the ones bringing forth the objection. So no, it is not Napoleon Harris' attorney's responsibility to prove he does live there when Napoleon Harris and his attorney don't have an issue with where Napoleon Harris resides. They don't have an issue with his residence. The objectors that brought this to the board, and this is based on applicable state law and election board rules, and if this were a judicial hearing, it would be a matter of court rules as well. It is not the responsibility of the respondent or the defendant to meet a burden brought from an allegation brought forth from the objector or the petitioner. The law does not permit that or support that at all. So for those who keep saying that, you need to read the law. Read a book on anything, but read the law. And that's not just in Thornton Township. Nope, that's the same law that applies across all 50 states in the U.S. It is the petitioner or the one that is bringing forth the motion or the petition or the allegation. Those terms pretty much come down to the same thing. Whoever's bringing this issue to the court or to the board for this administrative hearing to be conducted, it is their burden to meet. And because this is not a criminal matter. I've heard a couple of people comment on this, they got to prove beyond a reasonable doubt. This is not a criminal matter. They don't have to prove beyond a reasonable doubt. The burden to meet is a preponderance of the evidence. Is it more likely than not? But the key word is evidence. Preponderance of the evidence. So you got to have some evidence to be pondered on. I hate to say that, and I'm not trying to sound condescending, but it's really aggravating when these things can just be looked up and Googled and stuff, and you got Dumb and Dumber wasting tax dollars on this vile, vicious nonsense because they're mad that Napoleon Harris is on the ballot. Super Stupid is still not going to be on the ballot at the end of the day. So what is the point? What's the point again? Dumb and Dumber? What's the point now? This is not going to get her on the ballot either. And she's still going to lose even if you do a write-in. She's still going to lose. So why are you all still doing this again? I mean, it's getting dumb and dumb and dumb, as this goes on. So, God, I just want to show that part here just so y'all can understand in context. It's not the burden of Napoleon Harris or his attorney. Why can't they come in here and say that? Because the law says they don't have to. That's why. The law says they ain't got to do that dumb shit. The rules say they don't have to do it. The law says they don't have to do it. Many case law and precedents has been set. The hearings say they don't have to do it. The respondent and or defendant does not have to help the petitioner meet their burden. Because the law says it. Laws are laws. And that's it. And it doesn't care about how anyone feels. That's how it goes. So no. And if I were Napoleon Harris, I wouldn't show up for this bullshit either. Dumb and Dumb and just wasting tax dollars. And it's an insult. People should be getting on these two clowns for even going this far with this nonsense. You're still going to lose. Dumb and Dumber, in case you didn't know, Super Stupid has already lost because a judge in a court of law said you're not going to be on the ballot. Get the hell over and kick rocks. So why are you two still doing this? Wasting tax dollars. I wish people would protest the right way and say, all these idiots, that's out here doing all this nonsense like these two. How about we stop protesting them and making sure they understand they get the point? Stop wasting our tax dollars with your bullshit. Find another job and get another boss. And stop being a simp to Super Stupid. Funny how they always flip it at the mouth and they want to be smart mouth with everybody else, but they can't be flippant with one person. What the hell you owe her, Keith Chicken Nugget? You Big Mac? What you owe her again? You kiss her ass more than it seems like you kiss your wife's ass. I don't get it. Ugh. All right. Simply because reading is fundamental. Here are the Illinois statutes, chapter 10, elections. Statute 5-3-1, residency, citizenship, and age requirements for voting. This is for voting. Now, I was trying to find something very specific on when you're running for supervisor of Thornton Township. But I'm pressed for time right now. It's hot. But I'll allow you all to start here, and then you can go and research codes.findlaw.com is what we're looking at. And you can clearly see it's for the state of Illinois regarding voting. And most times, the rules regarding residency and age would be applicable if you're running for a position and or voting. You need to be in that precinct or district, however it's termed. You need to be age 18. When you're running for a position, Just like with voting, you can't be a convicted criminal of some sort. And of course, you must be a U.S. citizen. So the amount of time that you need to be in that district, and I'm just going to read it here, says every person who has resided in the state and in the election district 30 days next preceding any election therein, or who has resided in and is registered to vote from the election district 30 days next preceding any election therein, and has moved to another election district in this state within said 30 days, and has made and subscribed to the affidavit provided in paragraph B of section 17-10 of this act, or 3, who has resided in and is registered to vote from the election district 30 days next preceding any election therein, and has not moved to another residence, but whose address has changed as a result of implementation of a 9-1-1 emergency telephone system, and has made and subscribed to the affidavit provided in subsection A of section 17-10, and who is a U.S. Citizen of the age 18 or more years, is entitled to vote at such election for all offices and on all propositions. So this is kind of just the crux of it for the state of Illinois. When they're giving sections here, that means you need to go down to section, like, let's start with where it says B. The affidavit provided in paragraph B of section 17-10 of this act. Okay, so you will have to go and look at section 17-10 to understand what they're saying regarding that specific paragraph. So this will only be like if you've moved to another election district in this state within 30 days and has made and subscribed to the affidavit provided in paragraph B of section 17-10. So you would have to go to that paragraph B of section 17-10 to see the affidavit that it's referring to. That's when it would be applicable. The way this stuff reads, you may have to read other sections to understand what it's specifically citing and referring to, so that you can ensure that you are being compliant of the state statute. And these nuances, each of these, numeric number bullets here, 1, 2, 3, or section A and B, if it cites a different section of the act, go and read it so that you are still fulfilling the requirements of the residency and citizenship and age to be able to register to vote. And of course, it's not too much different when it comes to running for a position. Of course, you can't have a record. You can't be running around here convicted criminal, something like that, and you trying to run for a position like that. I don't even think they'll let you vote unless your record is expunged, or part of you got some plea deal or program by law where you can still vote. For the most part, I think there's some restrictions on that. So always look up and read and research this information. This is why it seems so ridiculous to me for them to be objecting to something like residence. And to prove residence, the law allows you to be able to produce your driver's license and to produce like either your mortgage deed or a lease agreement or a utility bill like the electric or water bill. Something to that extent where it has to be connected. The bill has to be in the address of the residence itself. It can't be like a cell phone bill. You can send a cell phone bill anywhere. So the fact that the driver's license and the mortgage deed or lease agreement for Napoleon Harris for some reason was not sufficient to Dumb and Dumber, who are not attorneys, is baffling to me. Like, why is that not enough? If the law says it's permitted, why in the hell are they making an issue? Worst part is, why is this dumbass election board allowing them to continue on with this nonsense and buffoonery? I get the impression that none of the members of the election board itself went to law school. And the only person that did is the election judge, who's really there to just give them legal advice on how it should be conducted based on rules and state statutes and township and municipal codes. But it's like they don't even listen to her. They need to be reminded it's not about their old ass egos. It's about what the law says. And when you have an attorney citing case law and making a valid point for any reason, when you're supposed to be following the law anyway, what the hell are we still doing this for? Honestly, y'all can go vote for who you want to vote for. But when you're challenging just one person in this, all because you still feeling salty about something, you better get the hell over it. Because I tell you right now, if this were a judicial hearing, every judge would have kicked their asses out of their courtroom. I'm dismissing this case. Get out my courtroom. All of you are dumb. Go home. You're getting on my nerve. And as a matter of fact, a couple of attorneys would have been sanctioned already. This has to be the most frivolous nonsense I've ever seen in my life. And I've seen some pretty dumb hearings. But good grief, this is just an administrative hearing at that. That's the worst part about it. So now that you all see the information on the Illinois state statutes regarding requirements for voting, regarding your citizenship, age, and residency, let's go to the last hearing that was like 5 hours long that I'm not going to cover all of, but I'm just going to touch on some parts of it. So, okay, so I'm just going to play a portion of this. Like I said, it was over 5 hours long. And I got this, the first clip I showed was from Burgundy Blues Commentary channel. So make sure you guys check out her channel for the full hearing. She was there and recorded it. That's Burgundy Blue Commentary for the first video clip that I showed. This clip is from Critical Smokers YouTube channel. Vivian Allen, your favorite survivor, was there as well. She was there the whole time. She literally has a 5 hour plus video on her channel. The issue is it's hard to hear. So while I watched her live stream, I was actually watching her live stream for the full time. Except when I went to the store, because at some point I just had to keep living life, and this thing was just long. But Critical Smoker was there. Reality TV Chicago was there. So you guys have, a few options to check out their videos. And I know Critical Smoker, he didn't stay the whole time. But I wanted to get the clip that had the best sound quality, because they spoke really low. And it's a struggle to hear. And I had to even put on the caption at one point. But this is Bert Olderson, y'all. He doesn't play. All of the respected attorneys that know laws and understand how this works, they don't play around with this. Whoever the two attorneys that Dumb and Dumber got, because they watched my video, the first one, and I just destroyed Michael Smith. I ripped that boy to shreds. And I kept clowning them on not being attorneys, because they're not. Him and Keith Big Mac, Biggie Size Me, are not attorneys. They're not. And they went and got an attorney. And the second hearing, I think the attorney was supposed to just kind of help present legal argument. This time, him and another female attorney are just on the case. So it's it's counsel and co-counsel. And I think they're paralegal. They were unprepared. They were in there printing, and that was making a lot of noise. You might hear that come up in the background. So just in case you're like, is that something printing? Yes, it was. It was Dumb and Dumber's attorney, paralegal, printing out some stuff because they were not prepared, because they don't have a case, because they don't have evidence to prove that Napoleon Harris does not live in Thornton Township, because reasons. They don't want to accept the driver's license. It's just too much to ask for to show legally acceptable documents that can prove residence. There's nothing for the man to tell you all when he can show you his driver's license, which is what they've already done, because you can only have one valid driver's license with one address listed on it in any state in the United States of America, because that's how that shit works. Yes, it does. No one has two valid driver's licenses with two different addresses on it. No, you do not. So, you certainly can't have one valid driver's license with two different addresses listed on that. You can only have one driver's license that's valid in one state with one address listed on it at a time. Period. Every state law is about the same when it comes to that. So my driver's license should have my permanent residence address on it, which it does. And when you get your address updated on your driver's license, guess what you got to bring with you to prove it? You got to bring a lease agreement or a mortgage deed or a utility bill. And that utility bill can't be every single bill you have. It can only be your electric and your water bill. That's it. That's all. So why is that not acceptable? These are the same legally acceptable documents that you can take to get your driver's license. For goodness sake, why is it not acceptable to show those same documents to an election board to keep your name on the damn ballot? Because Dumb and Dumber wants to waste all of you all's tax dollars on stupid things. Because super stupid threw a tantrum. The end. Let's get to it.
Yeah, we have three motions. I think Mr. Seckler's going to do the first one on the 237 motion, and then I'm going to do the one to asking the board to strike the submission of all the hearsay unmarked exhibits. But I would yield, if it's okay with the board, to Mr. Seckler to argue the first motion. We have hard copies if the board would like hard copies.
Yes.
There's three.
I wish they would speak up. Yeah, this is the boring part that I always tell you all about when it comes to law and hearings. They're very boring.
Shall we hearing first?
The first matter, that this is Ross Seckler, SECLER, on behalf of the candidate. The first matter to that
You're the lady in the leopard shirt.
is the untimely and frankly invalid Rule 237 notice.
Thank you.
Filed a response and objection thereto. And this gets to the fact that on a document that was entitled a Rule 237 notice to produce was emailed to the counsel, the Electoral Board, as well as counsel to the candidate from the Objectors Council. That was on January 29th at 9:41 p.m. saying that they want Napoleon Harris III to be here and to produce all these documents. As the board is well aware, the objectors requested and were issued a subpoena, among others, a limited subpoena for Mr. Harris to come. And under the board's own rules, service of those subpoenas have to be done as the same manner in the circuit court. Objectors failed to do that in any way, shape, or form.
So the service of the subpoenas themselves, there's a certificate of service that comes with that. That certificate of service is to have to go through and be filed with the circuit court. So I'm assuming it would be the circuit court of Cook County, right? Because that's the county they're in. So I can just only assume that correct me if I'm wrong with what court that falls within the jurisdiction or the district of the Thornton Township district, but let's just say it's Cook County, hypothetically. So they have to have those subpoenas served, unless they get their own third-party processor. It has to come through the court. The court, typically you get the sheriff's department to go out and serve the subpoenas. There is a rule that's not just a court rule, but the rule being derived from law, state law, that speaks to timely filing of production of documents. So you asking for like discovery or exhibits from the other party, as long as it's within the scope of the damn case. My Lord. If it's not within the scope, it can be objected to. And it won't be, and it's hard to say because this is not a judicial hearing. It's an administrative hearing. So some of the things they would have to go through the court to get. So the certificate of service for the subpoena itself would be one of those things. It has to be also considered within reason. You can't email someone saying, we want all these dumbass documents at 9:30 something p.m. when the hearing is the next day or 2 days later. And if it's too burdensome, they can't object to producing documents that is burdensome. That is a term that's an actual objection to production of documents. The task at hand and what they're requesting for is just too burdensome to fulfill. If it's just a waste of time, you're just asking for dumb shit and you don't even know what you're doing with it yourself anyway, then no. They can say, we're not going to do this, and here's the reason cited. You know, the request will be too burdensome to fulfill, and they're asking for stuff that's just beyond the scope of what the objection is based on. They're asking for documentation that, you know, will violate, you know, Napoleon Harris's privacy. It's that meticulous. So when people are asking, why can't he just do this and that? Because by law, he may not have to. He might not be required to do that stuff by law. The rule that they're citing, I think, is more so a court rule. It could be the Uniform Superior Court rule or circuit court rules. I don't know. They're just saying Rule 237. I do know there are court rules regarding production of documents and sharing discovery material. I mean, those are real court rules, but those court rules are based on state statutes. So it comes back down to what does the state law say about producing documents and serving subpoenas. You're serving a subpoena. You're saying you want someone to come in and to provide evidence through testimony. There has to be ample time to be provided to the person you're issuing a subpoena against based on the law. You can't just have someone come in the next day and subpoena someone for an administrative hearing on a dumbass objection that was not even filed properly, that you didn't even serve the subpoena to properly, and expect them to want to just come in the next day, unless they're just willing to do it. But you're trying to serve a subpoena like that automatically forces them. No, it doesn't. Don't work that same way with administrative hearings. Not at all. And if it's not done within a timely manner, and it's not filed properly, if it's not served properly, it can be objected to. That's what they're doing. They're objecting to, they're basically trying to get it, trying to strike those subpoenas, documents that were not labeled properly, that are beyond the scope of what the objection is about anyway, that are based on hearsay. So, well, so-and-so told me this and so-and-so told me that, or, I saw a picture or something. That picture doesn't prove residence. It doesn't prove residence no more than it disproves residence. So you looking at someone taking a picture outside their house, how does that photo prove they live there? I could go outside right now and take a picture outside of some house, some random house. The average person may assume that it's my house, but we don't work on assumptions when it comes to anything that's supposed to be based on a legal objection here. You can't work on assumptions. That's what the hearsay comes in at. It's like guesswork. So I'm just assuming that because you took a picture outside of a house, that's your house and that you live there. But if you can end up proving that that's not your house, or I accuse you of taking a picture outside of a stranger's home, and you're like, no, that's my house, but I'm accusing you of taking a picture outside of some stranger's house. That's what they're doing. Oh, he doesn't live in Thornton Township, but yet we have no evidence to prove it. We came into personal knowledge of it because we saw pictures of him at this other house here. Okay, but you got to prove he doesn't live in the home in Thornton Township in Harvey. You prove that he does not live there. That is your burden. They're not smart and competent enough to do that because they don't even know how to get evidence on it or serve a subpoena or file the objection properly or even fill it out correctly or to get it, preserved correctly. Like, why are you putting folds in it and staples? I don't understand. These are the dumbest things they're doing, and they keep fucking up every step of the way, showing their incompetence. And the attorneys are like, okay, they weren't filed properly. Now you got subpoenas that not being served properly. They're emailing us at 9:30 something at night, PM. They said PM for a reason. Because it is just beyond reasonable. With the time frame, you're asking for this stuff. And here it is, 2 days later. You just sent this email 2-3 days ago. If not the day before. What kind of nonsense is that? And you want a laundry list of documents you think you're entitled to. That's the funny part. They actually think they're owed this shit. No, you're not. Nope. And to all the citizens there, no, Napoleon Harris does not have to show you his tax filings. Why? Show us yours first. And don't even have your Social Security number on it. Oh, no, you wouldn't do that because it would be a violation of your privacy. Yes, okay. Kind of figure that.
The objectors in proving that, the objectors on the 28th of January tried to reach out to counsel and said, will you accept service of these subpoenas?
28th of January.
Mr. Harris as well as his wife. We said, no, you have to follow the rules.
Right.
Follow the law. Just like they did not accept service or didn't volunteer to accept service on behalf of the objectors, and for the subpoenas that we were granted as the candidate and we issued and did properly serve, they did not, would not just agree to limit the rules and allow them to shortcut the mandatory procedures
right
to compel someone to appear here. The board's rules of procedure are clear on this. I believe at the first initial hearing, and I apologize that I was not here at the initial hearing, but at the initial hearing, there was a long discussion about notices to produce, as well as subpoenas, and the key and clear thing was all of that had to be requested in advance and at the same time, within the agreed upon timeline. They did not request a notice to produce, they requested a subpoena. They issued a limited subpoena, and they did not serve a subpoena. They attempted and are going around, they're trying to backdoor and compel someone's appearance here when it does not have proper service and notice of those, to be here with those documents.
Right.
This is, it is just an it exemplifies, and as will be discussed in the other objections and responses, as was mentioned and discussed at the last hearing in this matter, this exemplifies the malicious mischief of this case. They don't want to input the resources to actually do and comply with the board's own rules. They don't want to comply with
state law,
with Supreme Court rules. They want to just shortcut that and spend as little amount of time and resources possible in order to waste this candidate's and this board's and this township's time, money, and resources. That is it.
Thank you. I'm so glad he said that, and I'm pausing it right there because I want you all to sink all that in. This is a very elegant, well-spoken, well-educated attorney here saying flat out, they're not trying to do things the right way based on, he said, Supreme Court rulings, based on the rules of the board, which should be derived from state law, state statutes. I mean, the definition of the term statutes is law. So from state law, that should govern how this damn election board conducts business and carries and conducts itself. They're not doing that. They're not applying the rules across the board to Dumb and Dumber who are wasting tax dollars. And then they want to sit here and make it seem like they're doing it for the people. No, they're doing it for super stupid. Because she commanded these punk asses to do it. Bottom line. And they're like, yeah, okay, we'll do it. But yet and still, what the hell she at again? Oh, okay. Still, man, still being dragged in by the rest of the world, calling her the worst mayor on earth now. I mean, she's being reported on in Australia. I've supporters in that Bless God Forum that are in Germany, Norway, oh Lord, Great Britain, Australia. I mean, Brazil, South America, Canada, leaving comments on my video saying, we know about her all the way over on a whole nother continent. Australia is its own continent, for goodness sake. And she is being reported on in Australia, where they shouldn't give two shits about her at all. She should be a no-name person. But no, this is what happens when you put yourself out there in the media because you're a narcissistic psychopath, and then you start getting the attention that you deserve, little girl. This is what happens. Then you start getting it. There you go. But these two clowns are just doing what she wants them to do. They don't care about how horrible and stupid this makes them look. Why would you all vote for Michael Smith and Keith the Big Mac to do anything after this? I don't care what your relationship is with him. He's an asshole who is showing his incompetency or willingness to be a big-ass lapdog for all the wrong reasons. There is nothing he should be gaining out of this. He doesn't know the law. Neither of them know the law. They did it wrong to start. And the case law that Bert Olderson was even citing, that stuff go over their head. The attorney from Napoleon Harris cited in the second hearing. Them case laws went over their head. They have no comprehension or idea what the hell that means. He's like, what do you mean by pleading? We did plead it. I can guarantee you that's exactly what they said to themselves. What are you talking about? We didn't make pleading. We did plead it. We said it on the paper. Yeah, okay. Yeah, okay. We'll let you just keep thinking that's the concept of it. Okay. They won't ever read the case law though. No, don't wait for them to do that. That's too much like right. So the guy's just saying basically what I've been saying. All of this has been done wrong. They don't want to put in the work into actually serving someone properly. The 28th of January, today is February 1st. So that was like 2-3 days ago. So you're trying to issue a subpoena to someone improperly on the 28th of January, sending emails at 9:30 something p.m. at night when people are trying to go to bed. And then you wanted them to come in on, this was yesterday, on the 31st. So they may have had 2 full whole days. That's improper. And I believe that for production of documents, the law gives you at least 30 days. And you can object to the request. Depending on what the actual request is, it's supposed to be outlined and entitled. It should show what it is, if you're asking for a paper document or a video or a photo or whatever it is. It has to be listed and named. And then the purpose of it has to be also detailed so that, the board or the judge, if this were a judicial hearing, can see if it does indeed relate to the matter at hand. Asking for tax documents just to prove residence? Are you kidding? When the driver's license can do that? No. What the fuck is going on? The driver's license can do that. Driver's license can prove residence because by law it does in any other situation. You can use your driver's license to register to vote, to actually go and damn vote. Why in the hell is it not good enough to run for an election? Are you kidding me? It is legally accepted documentation. And if this were in court, it would have been shut down a long time ago because no judge would be entertaining this buffoonery. None. They didn't even want to entertain her bullshit lawsuit in court on the same issue. Oh, I'm filing a lawsuit because Napoleon Harris didn't tell me stuff and I'm not on the ballot. No one cares. And then they filed it to the wrong court. The incompetency is just staggering. Doesn't matter who it's coming from. Anybody affiliated with super stupid, it's like she just Day by day, she just kills off brain cells. Just murdering brain cells day by day. Girl, she wants everybody to be as dumb as she is, and if not worse. So, that's the gist of that. I would look up Rule 237, but I have to be sure that this, I don't know if that's a uniform superior court or uniform rule for circuit court. I'm not quite sure. So that's why I'm not looking it up, because I'm sure that it's just a general rule across the board with the production of documents for any type of hearing, whether it be administrative or judicial. But I want to pull up the correct one. So them just saying Rule 237, I don't want to make a mistake and show something wrong. That's the only reason why I didn't Google it. But you guys can feel free to look it up and research it. And I just, this thing just, it gets worse. So I'm going to play a little bit more of it so you guys can kind of get a gist of my frustration. And
they don't want to do the work. They want you to do the work. They want us to do the work, and that's it.
Yep.
And that is my big problem. They have the burden.
They have the burden.
Production, and they have the burden of proof.
Yep.
They have failed there, and this request is demonstrative of the bad faith nature of this objection, and we request that it be denied and rejected. And further, we part of that is
you made your point.
Yes, thank you.
And objector, did you bring us her?
So, he made his point. These board members up there, y'all should make y'all point and have their asses voted out and replaced. Because they're not even trying to listen. It's like they just want Dumb and Dumber to win this thing by however means. I don't know. And the issue with the burden of proof thing, y'all gotta, like I said, don't forget, this is not a criminal case matter. Okay, this is what will be considered civil, but it's not even a judicial hearing. It's an administrative hearing. So no, Napoleon Harris's attorney, they're just there to defend their client against the dumbass objection that these Dumb and Dumber people raised up that aren't based on any finding of fact or law, because it's not, because they have not proven that. You could bring an objection up, but the objection is not a legal objection when it's not based upon any finding of fact or law. They're just saying he doesn't live somewhere, but they're not proving how he doesn't live there. Especially when he has a driver's license. Like, if they had to go to court with this, that's all really the judge would be like, listen, do you have proof of residence? I mean, they would clearly outline what that proof would look like and what the judge would expect. And then if they could produce it right then and there, they would. And the judge would be like, well, he has proof of residence right here. So why are you all here? All right, this is done. I'm dismissing this. I mean, they can prove residence. You all have not proven residence by showing me evidence he does not live there. It would have been dismissed a long time ago. And acting in bad faith. Okay. The malicious mischief. That's no different than saying malicious prosecution. It's bringing forth a petition or filing a pleading or a motion in bad faith, where you're basically doing it to waste taxpayers' money and time, or to be a distraction, or to prolong something for the sake of it being prolonged, because there's no point being reached in this. And the dumbass election board members are entertaining the buffoonery. That's the worst part. That's what's more aggravating than Dumb and Dumber kissing Super Stupid's ass by even invoking themselves into this nonsense. Because I guess they thought they would have something to gain out of this. They don't. That girl don't care about y'all. She just cares about herself. She's sending out the bigger idiots to do her work for her. To do her dirty work. And they're sitting here somehow willing to do it. For reasons. You're not getting anything out of it, because she's not going to be supervisor of Thornton Township. She's just not. She's not. The court has already said, if you want to be on that ballot, you got to be a write-in candidate, and you better be eligible to do that. Which she's not right now. So, the only thing that she has going for her is just hoping that, I guess, a miracle happens and she can bully the entire village of Dalton and end up being mayor again, because that's exactly what she would have to do. That or cheat. And I hope she does not succeed in any one of these positions. She should kick rocks and fall into the middle of the earth and keep going. I would be happy with that. Just, you're wreaking havoc in people's lives and you don't care. And people out here trying to make excuses for it, and it's disturbing to me. Your mindset is disturbing if you're trying to make excuses for it. I don't have to give her the benefit of the doubt. When there's plenty of documentation and evidence, there's enough knowledge out there to see what she has done has been criminalistic, if anything else. But definitely damaging to other people and their livelihoods. Too many people are being affected negatively by her. So no, I don't owe that heifer the benefit of no damn doubt for any reason. This is not a hatred. This is someone that thrives on making other people miserable. As long as you're loyal to her, then she probably won't target you too quickly. But who says that Keith Bickback and Michael Smith, who still knows nothing, you're still stupid, you don't know government or law? Who says that at some point she's not going to turn on them? Because they will fail at this. This is going to be an utter failure for them. And the way they're going about doing this, they're doing this to be malicious. She's not going to be on the ballot for Thornton Township supervisor. So why continue to push the needle on it? Because they're being malicious about it. It's all about ill intent. There's no good intention. They're not seeking a reasonable resolution. They brought forth no damn evidence on it. And the next 3 hours of this insufferable nonsense and garbage was all about them talking about how they go around taking pictures. They had about 2 or 3 witnesses come in, testify. One of them being a current mayor who's seeking to upseat and run against Napoleon for the supervisor. What's his name? Christopher Clark? Whatever. Somebody Clark. I don't care what your name is. But he's came in and testified. It sounds dumb. And Napoleon Harris's attorneys, they forget, has the right to cross-examine, even if Dumb and Dumber's attorneys subpoena someone to come in, or they just were willing to come in and testify. You are subjected to being cross-examined. When you have these 3 attorneys that are the smartest people in the room, and Dumb and Dumber's attorneys that are sitting over there being the goofballs that they are, not even knowing how to phrase a question, and half of the objections that Napoleon Harris' attorney was making were sustained because they were viable legal objections. And it's like a fishing project that anybody, you don't have to go to law school to see that they're fishing for something. All we ask is that you produce evidence to show, not photos of him being in a car or outside of a home. You taking pictures of his garage door. Michael Smith is a damn stalker. And it's disturbing as hell. You taking pictures of this man's house. You were going by his home at some address or some home you claim he live at or don't live at. You going by the house to take pictures on your way to church. That's what he testified to. I suggest you all watch Vivian Hallen's video. She got the entire video. And it screams stalker. And it's disturbing. A grown man trying to keep up with another damn grown man. Who the hell does that? Who does that, Michael Smith? Ye who thinks that he knows government. Who does that shit? You driving around taking pictures of Napoleon Harris all day? That's a stalker. How can anyone not be disturbed by that dumb shit you're doing? Go home to your spouse and your children and go read a book. Get a job, because you're going to need it. Find anything else to do. Because this bullshit you're doing, you're literally setting yourself up to look like you ready to stand before a court and stand before a judge. And whatever they say to you and do to you, you had it coming. Because you're saying all of this on videos that's being live streamed. How you go past this man's house or past addresses where you think he does or does not live at and take pictures. Did you see a garage? Did you see a chimney? Like, it gets really stupid, y'all. And I can't go over the whole video. But that goes and adds to what they're doing being done with malicious intent. They're not doing this in good faith. I mean, they're simply saying, y'all want to sit here and subpoena people? Do it the right way. They won't even do that right. They didn't file the objection correctly. It was improperly filed. I thought I was saying like it was properly filed. No, you don't understand what improper means when it comes to these court documents. It was not properly filed because it was not done according to the rules and state law on how those documents are to be completed, to be affirmed and verified, to be notarized and preserved and produced. There is court rules and state law and election board rules on how those documents are even to be produced. So when I say it's improperly done, it means it wasn't done according to the rules or the law that defines how it should be done. So it's considered improper. And that's all that Napoleon Harris's attorneys are saying here. They're not even serving people properly. Why are we here still catering to this bullshit? And guess what the board ends up doing at the end of the day? After 5 hours, they still want to move forward with forcing a subpoena on some random ass neighbor. And they got to go to court to do that. And guess what the judge going to do? What the hell is this? I'm not signing this. So you can't force a neighbor to come in. How do you know that neighbor is going to testify to this stuff? What if they go in and say the opposite? And then you would have forced them to come in, and then they're going to be mad at you for forcing them. They might not even want to be involved with this. How does that add to your case? Did this person say they're willing to come in? Now you're going to force them to come in? Why? If they don't want to come, then if you got to go to the court to force a subpoena for an administrative hearing, obviously that person doesn't want to have anything to do with this bullshit. Because they probably have seen Michael Smith driving past his residence, taking photos of it, stalking the shit out of it. They don't want to have anything to do with this crap. And if they don't cooperate, now you got to worry about these goons showing up at their house and harassing them. Of course they're not going to want to have anything to do with it. These people are willing to do any and everything that it takes to intimidate and threaten and fearmonger and lie and lie and lie some more just to try to get their way. All in the name of super stupid. No one is going to want to have anything to do with this bullshit. And you can't blame them. And the judge is going to remind them of that. And hopefully the judge will deny that dumbass thing and say, I'm not going to force some random neighbor to go in and testify in this bullshit hearing where it's simple. Do you have evidence of his residence? Yes or no? Here it is. So why are you all sitting here going through all this nonsense? Hopefully they get a judge that's sick of them and willing and ready to say that at a whim's notice and deny the damn subpoena from being forced and to compel someone to go in and testify to something simply because you're punishing them for living next door to this address. Why? Oh, because I live that down. You think I want to be a part of this bullshit hearing you're having here? I don't want to be a part of this. Leave me out of it. If you got to compel them, they don't want to do it. They don't want to participate. And going through the courts to compel them is not going to do anything but piss them the hell off. And you will have whatever comes your way. Preferably they sue y'all asses for this. If I were that neighbor, I would sue them. Sue them. Please sue them. Because it is malicious mischief. It is malicious. There's just no good intentions about any of this. So sue them for harassment. These two black men came in my driveway talking about I have to be forced to come and testify because I'm a neighbor to someone. What the hell? Oh. Who knows? All right. So that's all I got on this. I can't do it anymore. I just can't. This was goofy as hell from the beginning. I've been saying this. This is dumb. I'm glad it's all over the videos and on YouTube because I want you all to feel my misery on this. Please subject yourself to that 5-hour hearing. Just, if nothing else, it'll be great ASMR to go to sleep to. because it's boring stuff. But if you understand how this goes even a little bit, it's going to frustrate the hell out of you. So, yeah, might want to do whatever you can to relax before you watch it, because you'll find yourself yelling at the phone. This election board's got to go. That lady in the leopard top sitting next to the election judge, she has to go. Y'all need to fire her ass or find a way to vote her the hell out. You need more representation on this board as well. They're all white. Not one person that can actually understand how people feel and would say, we're not going to do this. We're not going to keep draining tax dollars on this dumb shit. You guys can't prove that he doesn't live in Thornton or in Harvey or wherever. Then we got to keep living. That's y'all burden to me. If you don't like it, then oh well. Because a court of law has already said, goodbye, girl. You're not going to be on the ballot through this means. That lawsuit was frivolous. It was stupid. It was not filed right or properly in the proper venue. It just got botched and screwed up because you got incompetent people doing dumbass shit listening to super stupid. All right. Hope you guys enjoyed that. That's all that I have here. Make sure you hit the like button, subscribe, and share this video. You guys have a good laugh and nothing else, because you got to laugh to keep from yelling at the phone. And I have more content coming out. I have my other video that I did today. I went over the more footage of that fight with Super Stupid, and then of course went over her interview where she did nothing but falsely accuse someone of having a knife or a weapon, with all those witnesses there that could easily testify against her and say that there was no weapon, no knife. It was so stupid to even make that dumbass false claim. That's a flat out lie. And it could be defamatory. You accuse someone of having a weapon with the intent to harm someone. That's slander. So her and her attorneys still aren't smart enough to get a clue. And, you know, all the shit that they're doing and all the L's she's taking in court is proof of it. I don't know why the attorney didn't ask her, how did you end up in direct criminal contempt of court again? Yeah, okay. Y'all make sure y'all hit the like button and share the videos and check out the other content on the Super Stupid playlist, because it's there. And podcast here on LadyLuckClub. Want you guys to have a good evening. Take care. Lady Luck out. Deuces.